Did you know that the Supreme Court is going to hear two cases that may completely upend the way content is moderated online? Now, before we get into it, consider this. You probably know that shortly after purchasing Twitter, Elon Musk tweeted, "The bird is freed." And you probably also know that he stated that before making decisions on who to reinstate, he's going to create a moderation council, though details about this council are slim at best. We don't know who's going to be part of this council. We don't know how they're going to decide, and we don't know what recourses, if any, are going to be available based on the decisions that the council makes. And you probably also know that shortly after making these announcements, the use of a specific word on Twitter went up 500%, which I think is pretty telling of the inclination of some people on Twitter. Now back to the Supreme Court. There's a law on the books known as the Section 230 of the Communication Decency Act that states that no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. This is a convoluted way of saying that social media platform cannot be held civilly liable for damages caused by what other people that participate in the platform are publishing. And the Supreme Court is going to hear two cases that have to do with this shielding of liability. One of these cases is Gonzalez v. Google, which was brought on by the father of one of the victims of the Paris attacks in 2015. And in it, the applicant is stating that Google is partially responsible for the events of that day because YouTube was recommending video that basically radicalized people. So this one has to do specifically about the recommendation feature on YouTube. Now there's another case known as Twitter v. Tamne that is connected to the first one because Twitter basically asked the Supreme Court, if you're hearing the first one, Gonzalez v. Google, you gotta hear us too. And this one is specifically about content that is published by extremist groups on Twitter. And it centers around the company's responsibility to moderate that content. Now, if these cases are decided against Google and Twitter respectively, that would make Section 230 a moot statute. This would basically open the way for civil suits brought against Twitter, YouTube, Google, you name it, in instances where their lack of moderation is basically and allegedly contributing to damages, violence, and so on. And let me tell you something. If Twitter becomes liable for lack of moderation, this tweet right here becomes one of the largest liabilities on company record. So this is a reminder to Elon Musk that economic and commercial liberties come with rights, but also with responsibilities.